Gray, Vice Chair White, Ranking Member Leland, and fellow members of the Criminal Justice Committee. We've all been here all morning. And frankly, most of what I had planned on preparingly saying has either been said 100 times better by the people that have gone before me or have been changed by the amendments that have been adopted earlier. So I will attempt to be incredibly brief. I've been a bail bondsman for over 20 years. I've arrested hundreds of bail jumpers. I've posted either directly or indirectly through agents thousands of bail bonds. I originally wanted to speak about what the purpose of bail is, but I think it's been adequately explained that bail is a liberty-promoting enterprise. It seems to be categorized as some kind of detainment scheme within the purpose of this discussion, but when we look back, our founders very clearly wanted the sole means of release not to be in the hands of the state. That was a system that we fled from and fought a war to maintain. The reason that bail exists is so that there exists a system that outside of the direct influence of government for someone to be free while they are fighting their charges. That being said, there are just I'm going to very briefly touch on three parts of this bill that I feel would greatly curtail individual rights because, quite frankly, as I said before, the specifics have already been pretty thoroughly and correctly went over. When it comes to the financial disclosure, Representative Seitz very insightfully points out that there's a huge chance that these disclosures will not be answered accurately, or in some cases, will not be able to be answered accurately. So essentially, how I perceive the amendment is we're just going to tack a 15% penalty on to lying, when my expectation would be that lying on an affidavit would be tantamount to perjury. But it seems that we're just all going to concede that if we catch you lying, that we're just going to tack 15% on and move about our day. So basically everyone that either can't or refuses to disclose their financials is going to pay 40%, but 40% of what? What mechanism, what bureaucracy is going to be placed to determine the veracity of these affidavits? I say my income is zero, you say it's not. Where do we meet on that? Are we going to attribute income to people as we do in other indigencies? Well, you look like the kind of guy that makes $35,000 a year, so we're going to move from there. The money, the manpower, and the resources it would take to obtain, collect, and safely store this data is, quite frankly, in my opinion, outside of the resources available in Ohio to do in 88 counties, all municipal and common police courts. It's just not practical. Not to mention the fact, are we counting a spouse's income? Can you, as a criminal court, compel a spouse who's not a party to the criminal case to give a financial disclosure? Are welfare benefits, Social Security income, unemployment, are those income under this scheme? Or would they just merely be an asset? Are assets counted? If you have an inherited home worth $500,000, but you are retired and you commit a crime, is that home, because you have no income, are your assets not part of this? I don't know. Secondly, the preventative detention piece of this. Out of this whole thing, the preventative detention piece bothers me the most, which may surprise you because I have made my living for 20 years getting people out of jail. However, it's very clear that preventative detention destroys the presumption of innocence, and that has been said much more eloquently than I'm going to say it. But bail preserves the presumption. It creates the balancing act of the probable cause that there was a crime committed versus the individual right of the person to maintain their liberty and prepare their own defense and maintain their life, not just employment, but just their pursuit of life, liberty, and happiness as the government proceeds with their case. As I understand it, the list of offenses that have been up for preventive detention is being continuously narrowed, but there are cases where, quite frankly, and one that I saw, vehicular manslaughter. Now, absent some very extenuating factor, let's say that the person was not intoxicated, but they were charged with this crime because of a an error in judgment, perhaps they were speeding, perhaps they were not wearing their corrective lenses. Does preventative detention really serve the community? That person is going to go out and wreck into someone else willfully like that? I would say the odds of that are very low. And these are all unintended consequences that the legislature, frankly, cannot foresee that will come into this bill. That's why discretion is so vitally important, because discretion allows a judge, a prosecutor, and the court to determine these individual factors on a case-by-case basis. Marcy's Law, which was mentioned by the young lady, the domestic violence representative, appears to be kind of an unknown factor as to how Marcy's Law will interact with this law. And an interesting facet of Marcy's Law is a victim is allowed to essentially hire private counsel to represent them in proceedings, and one of those proceedings would be a detainment hearing. So, in theory, if you had a contentious divorce on the horizon, one could provoke or perhaps manufacture a domestic violence charge, hire an attorney, very passionately argue for detention, contest the financial disclosure, all with the intention of that same attorney, who has essentially become a private prosecutor, going across the hall and filing for divorce, perhaps with the other party in the divorce detained, unable to hire divorce counsel, of which I know of no constitutional right to divorce counsel, unlike criminal cases. It just appears that, and we don't know how these two laws would interact. Obviously, you have to safeguard the rights of victims. That it's tantamount that those rights be protected. But if I'm just a good old boy, and if I could figure out on a short reading of this bill that there are places where this system can be gamed, people that are much smarter and perhaps more sinister than me are going to figure out in short order where the loopholes are and exploit them. And what I've heard today is essentially a risk management argument, trying to weigh how we protect best the majority of Ohio citizens, weighing against individual rights. And our current system no system is perfect. Our current system does a very good job of that, because our system is somewhat leans towards the rights of the individual in most cases, because when we start using things like preventative detention as a fallback, how many innocent people are okay to detain on the premise one of them may commit a heinous act or be guilty? Is it 5? Is it 500? Unfortunately, there is no system that will eliminate risk. And to try to assume that we can precognitively predict who is most likely to snap or who has got the most sinister intent, well, that's a Tom Cruise movie. That's not reality. And even in that movie, the system wasn't perfect. So there are definitely tweaks that need to be made. I think that Mr. Black talks about amending the bond schedule for misdemeanors, that in procedural crimes, where there are no victim, where the state is the victim, that there should automatically be a presumption of release. And unless there's a reason to overcome that, such as multiple failure to appears, contempts, mental instability, those are the people that I would assume are being championed by the reform movement. The kid that stole a candy bar and made a mistake should not spend 5 days in jail waiting for a detention hearing or bail hearing. He should be cited and released. He should never even be able to describe to you what the county jail looks like. He should never be there. But I doubt anyone here or any of the proponents of this bill are championing, the 5-time drug trafficker or the gun enthusiast that goes to a bar and shoots someone because he's intoxicated and stupid. So I believe there's a pathway here to do some social good, but I just feel like lumping the felonies and the misdemeanors in on some of these things, we kind of lost sight of the forest and the trees. The nonviolent misdemeanor offender, the procedural crime, there's no theory under which a driving without financial responsibility suspension should ever be prioritized for arrest over a domestic violence or even a felony theft or receiving, where there's a greater stake in this. So again, I apologize for speaking somewhat extemporaneously, but most of the better points were already made by the persons that went before me. So I thank you, and if there are any questions, I will do my best in my humble ability to answer them.
Thank you, sir. Are there any questions for the witness? Seeing none, thank you for your testimony.
Thank you, Your Honor.
So I think this brings us to our last in-person